Is counsel ready? Yeah. Okay, thank you, Deputy. Okay, please be seated. Okay, members of the jury, I apologize for getting your lunches late, so it won't happen again, okay? All right, Mr. Frank, you may continue.
Thank you, Your Honor. Professor Stoughton, I think when we took the lunch break, you were telling the jury something about the incident, and I think you actually just used the wrong name. I think you used Ms. Potter's name instead of Sergeant Johnson's name. But can you then just tell us what you were telling the jury just before we broke?
Yes, and I apologize for that error. My point was that there are situations where a reasonable officer on the scene will not know what another officer is doing. And in this case, Sergeant Johnson testified, for example, that he did not know what Officer Lucky was doing at one point.
And how does that inform your opinion about what a reasonable person in Officer Potter's position would have known at the time of firing the fatal shot?
Sure. So back to the determination of whether a reasonable officer in Officer Potter's position would have identified an imminent threat of death or great bodily harm if the reasonable officer was not aware of Sergeant Johnson's actions, for example, was not aware that he had entered the vehicle, then there would be no imminent threat. If a reasonable officer in Officer Johnson's position was aware of that, and was also aware that Sergeant Johnson was preventing the vehicle from moving, or was aware that Sergeant Johnson had exited the vehicle prior to the shot being fired, then there would be no conclusion that there was an imminent threat of death or great bodily harm.
If a reasonable officer in Officer Potter's position had been aware that Sergeant Johnson was in the vehicle at the time she used deadly force, would it have been reasonable for an officer in that position to use deadly force?
Assuming that the reasonable officer would have been aware that Sergeant Johnson had entered the vehicle and would not have been aware that he had prevented the vehicle from moving and that he had exited the vehicle, the use of deadly force would have been proportional. That is, it would not have been excessive based on the imminent threat of death or great bodily harm. It still would have been inappropriate because of the proximity of two other officers and the passenger.
And what if, you've reviewed the body-worn camera videos in this case?
Yes.
And you saw during these moments leading up to the fatal shooting where Mr. Wright was positioned.
Yes.
And does it inform your opinion regarding the use of deadly force, whether or the fact of Mr. Wright's position during these moments?
Yes, it does. If he's not in a position to get the car moving, for example, then there wouldn't be any particular imminent threat of someone getting dragged by a car that couldn't move. So the fact that Mr. Wright was fully in the driver's seat, the fact that his hands were in the area of the wheel or the shifter, the fact that his feet were on or in the area of the pedals, all suggests that he is in a position to make that vehicle move without a whole lot of trouble. That's relevant because of a great deal of guidance to officers to not use deadly force against vehicle operators. Vehicle operators here being someone who is either driving a vehicle in motion, or is in the immediate position of being able to put that vehicle into motion. And the reason for that guidance is because shooting someone in that position is highly unlikely to actually address the threat presented by the vehicle. So generally accepted police guidance now is to not shoot at a vehicle when the vehicle itself is the weapon. You might return fire if someone in the vehicle is shooting at you, but when the vehicle itself is being used as the weapon, you generally don't want to shoot at it, because if the use of deadly force is effective, that is, if it kills somebody, at best what you've created is a potential unguided hazard, and it's highly likely that someone's going to stomp on the accelerator or lose control of a moving vehicle or a vehicle that they set into motion.
Would it be consistent or inconsistent for a reasonable officer in Officer Potter's position at the time of using deadly force to believe that there is an imminent threat of death or great bodily harm to others, and yet and also believe that the person was not operating the vehicle?
No, those are contradictory and inconsistent with each other. If you believe that the vehicle is not in a position to be put into motion, then there is no imminent threat. If you believe that the vehicle is going to be put into motion, then you really don't want to use deadly force against that individual, because you're liable to make the situation worse, not better.
Now, I want to ask you to assume another fact for purposes of your testimony today. I would ask you to assume that Officer Potter, or that a reasonable officer in Officer Potter's position at some point during this episode had seen what she described as a scared look on Sergeant Johnson's face. Would that affect your opinions today?
No.
Why not?
Use of force situations are scary. There's, I suppose, the inherent difficulty of accurately reading in a high-stress environment someone else's facial expression. That is, an officer could misread frustrated or stressed as scared. And two, just because someone else looks scared really doesn't help inform whether they are scared, whether they are reasonably scared, whether that, even if they are scared, whether they are scared of an imminent threat of death or great bodily harm. It's not particularly communicative of anything relevant to the analysis.
Now I'm going to go to put up Exhibit 13, please. And I'm going to ask you to please go to 20201. Would you agree, for our purposes today, that this is at or right after the moment the shot was fired?
Yes.
And do you see anything in here indicating that Sergeant Johnson was visible to Officer Potter?
No.
And so then, based on all this, do you have an opinion to a reasonable degree of professional certainty as to whether Officer Potter's use of deadly force in shooting Mr. Wright with her gun was justified?
I do, yes.
And what is that opinion?
that the available evidence leads me to conclude that a reasonable officer in Officer Potter's position would not have concluded that there was an imminent threat of death or great bodily harm, and thus that the use of deadly force was excessive, that is, disproportionate to the threat presented. And regardless of whether the reasonable officer would have perceived an imminent threat of death or great bodily harm, the use of deadly force under the circumstances was inappropriate because of the danger that it created to the other two officers and the passenger in Mr. Wright's vehicle.
Now, I want to turn to the decision to use a taser.
Yes.
And have you also formulated an opinion about then Officer Potter's apparent decision to use a taser?
Yes, although she did not actually use a taser, as I said earlier, I believe the evidence indicates that she intended to use a taser. So yes, I've come to a conclusion about the apparent decision to deploy and discharge a taser.
Now, would this be considered the use of force, regular force, or deadly force? How would you characterize it?
The use of a taser is, under most circumstances, properly considered a less lethal use of force. There are situations where it can carry a substantial likelihood of death or great bodily harm, but under most situations, the use of a taser is considered an intermediate or less lethal weapon.
And what is the standard for the type of force or amount of force that an officer can use when it's less than lethal force?
So again, adopting that same framework or perspective of the reasonable officer on the scene, the question is whether the use of less lethal force is objectively reasonable, that is, reasonable to the reasonable officer on the scene. I apologize for double reasonabling you, but that's the standard.
And so in reaching an opinion, did you attempt to determine whether there was a threat at the time of using attempting to use the taser?
Yes, I did.
And what did you conclude in that regard?
I concluded that Mr. Wright did present a threat of escape. That is, there was an ability, opportunity, and apparent intention to flee the arrest. That the officers had the legal authority to detain or arrest Mr. Wright, detain him for purposes of dealing with the traffic violations as well as the investigation into potential marijuana possession, and arrest him for the outstanding warrant. So by attempting to flee the way he did, he was presenting a threat of escape.
And what about the possibility of apprehending him later? Are you factoring that into your decision today, your opinion today?
Yes. So when the threat being presented is the threat of escape, it is important to note that we're talking about the threat of escaping custody right now. There are a number of situations where there are tactical benefits or officer safety benefits to not arresting someone immediately, to arresting them later. Of course, you have to know who they are and have some idea of where to find them. In this case, the officers had information about who Mr. Wright was, who his brother was, their various addresses and contact information. So although he did present an imminent threat of escape, it certainly factors into the analysis that he was unlikely to avoid future apprehension. In a situation like that, officers typically either go and get him on the outstanding warrant or have new warrants written up and go and find him later.
And did you all also, in coming to this opinion, consider whether there was a threat of harm presented by the situation at all?
Yes, I did.
And just briefly describe for us what your opinion is in that regard for this situation, the apparent attempt to use a taser.
Yes, so rather mirroring the opinion with regard to the use of deadly force, the reasonable officer in Officer Potter's position would not have identified an imminent threat of physical harm from Mr. Wright. The evidence is that he was not assaultive, it's merely that he was trying to flee. And again, we've already talked about the positioning of Sergeant Johnson and a reasonable officer's awareness of that.
So you've just addressed any potential threat from Mr. Wright, correct?
Yes.
Threat of harm, I should say.
A threat of physical harm, yes.
And then you did also consider whether there was a threat of harm to the other officers at the scene.
Yes, that's correct.
And we've already gone through that. With regard to the deadly harm, is your opinion about the threat of harm essentially the same?
It is substantially the same, yes.
And did you also consider the appropriateness of the actual decision to try and use the taser?
Yes, I did, using that same framework of trying to identify foreseeable effects and weigh them against the foreseeable threat, or the effects of the threatened behavior, the threatened escape in this case.
And what is your opinion, do you have an opinion to a reasonable degree of professional certainty about the decision to attempt to use a taser at that point in time?
Yes, I do.
And what is that opinion?
Taser use is inappropriate under those circumstances for very similar reasons as why using deadly force against the operator of a motor vehicle is inappropriate. It's really dangerous to incapacitate the way that a taser can incapacitate someone who is in a position to get a vehicle moving. You can create an unguided hazard. If the taser was effective in achieving what the manufacturer refers to as neuromuscular incapacitation, and if the taser was ineffective, if it did not achieve neuromuscular incapacitation, if it just caused pain, what we call pain compliance, then you're providing an incentive for someone to flee in that circumstance. So you're likely to actually incentivize someone to effect their flight.
Are you familiar with taser training?
I am, yes.
And how a taser operates?
Yes, I wouldn't identify myself as a technical expert in all of the electrical components, but as a use of force tool, yes, I'm very familiar with it.
You're familiar with some of the reasons why there might not be a successful taser discharge, as you referenced earlier?
Yes, absolutely.
And in this situation, based on your review of all of the evidence, what have you identified as the potential problems achieving a successful taser discharge?
The single biggest problem is lack of probe spread. So to be effective, the taser has to send little micro pulses of electricity from one spot on the body to another. Neuromuscular incapacitation is effectively involuntary contraction of the muscles that really occurs between where the two prongs hit, or maybe in the area immediately around where the two prongs are. Essentially, electricity flows from one into the other, and while it's passing through the muscles in between, it causes contractions. So when the taser spread is big enough, which Axon's, the manufacturer's general guidance is in the 7 to 15 feet range, and what some guidance says is in the 10 to 12 foot minimum range, the prongs are more likely to spread out and hit the body in a way that they're distant enough that they cause neuromuscular incapacitation. When the taser is too close to the person when it's discharged, the prongs don't spread out sufficiently. They hit too close together. So the area of involuntary muscle contraction is very, very limited. It's very painful, but it doesn't cause the type of incapacitation that results in the dysfunction of the body. That's why it's pain compliance, that is, using pain to try and obtain someone's compliance, as opposed to what's often referred to as motor dysfunction, where you're preventing the body from working the way that the person wants it to.
And so, based on your review of all the evidence, information provided to you in the case, was Mr. Wright's position relative to Officer Potter at the time a factor in whether the use of the taser was appropriate at the time?
Absolutely it is. That's part of the determination about whether you are likely to achieve neuromuscular incapacitation. In other words, it's about the foreseeable effects of the force option of the weapon.
In your review, was Mr. Wright in a position to operate the vehicle?
He was in a position to operate the vehicle immediately before and at the time of the taser. we'll say the intended taser discharge, yes.
So do you have an opinion to a reasonable degree of professional certainty on whether it was reasonable for an officer in Officer Potter's position to decide to use a taser when she grabbed her gun instead and shot Mr. Wright?
Yes, I do.
And what is that opinion?
The use of a taser under the circumstances was unreasonable and inconsistent with generally accepted practices. If the taser had not been successful in achieving neuromuscular incapacitation, if it had just resulted in pain, it's highly likely to just incentivize Mr. Wright to flee, the exact opposite of what it was apparently intended to address. If it was successful in achieving neuromuscular incapacitation, it created the potential to turn the vehicle into an unguided hazard. Even if the probe spread locks the muscles, involuntarily causes muscle contraction between where they hit, does not mean that the person's extremities are affected. It's entirely possible for someone to stomp down on the gas, for example. So either way, in that situation, whether the taser was successful or unsuccessful in achieving neuromuscular incapacitation, the results are not good for the police.
Are you familiar, based on your training, your experience in this field, with the topic of weapons confusion, confusing a gun?
I am, yes.
And have you done some research into that history?
Yes.
And is this something that is known?
It's very well known in policing, yes.
And are you familiar, and have you learned approximately how often this has happened?
Yes, I have.
And approximately how often has it happened?
So tasers, as we now know them, were introduced in 1993. Since 2001, which is the first taser weapons confusion case that I'm aware of, there have been less than 20 incidents of weapons confusion, where an individual officer uses their firearm thinking that it was a taser.
And have there been things done to try and avoid those things from happening?
Yes, the manufacturer, policing, individual officers, there are a range of steps that seek to avoid the cases of weapons confusion.
Can you describe those for the jury, please?
Sure. So I think we can probably break them into three buckets. The first bucket is how the weapon is actually carried. The early taser confusion cases, actually almost all of the taser confusion cases, involve what's called a strong side draw or a dominant side draw. This is when the taser is holstered on the same side of the officer's body that the firearm is holstered on. The first, actually, I forget the exact number. It's at least the first 9 or 10 or 12 weapons confusion cases involved this same side or strong side draw issue. After the first couple of taser confusion cases, Axon, then Taser International, the manufacturer has since changed names, and other commentators began to suggest, recommend, and in many cases now require that officers carry the taser on a non-dominant side, what's sometimes called a reaction side, on the opposite hip than the officer carries their firearm. Going a little bit further, there have been a couple of taser confusion cases involving non-dominant side cross draw or reaction side cross draw. That's when an officer who is right-handed would carry the taser on the left hip, but in a way that they have to reach across themselves to draw it. So it's often recommended today, and many agencies require or strongly suggest that officers carry the taser holstered in a non-dominant side or reaction side straight draw. That's where the officer uses their non-dominant hand, whatever hand is the opposite one that they use for their firearm, to actually draw the taser. If you picture the way that a weapon is holstered on an officer's belt, if we're talking about a right-handed officer, the taser would be on the left hip, handle facing backwards, to be drawn with the officer's left hand. That's the first category.
And what's the second?
The second category is the training and education that officers get about weapons confusion. The potential for weapons confusion is a real issue in policing. It's very well known in policing. It is part of Taser training, and the warnings and the written documentation, the PowerPoints, the training materials that officers get. Be aware that this is an issue. And then officers are required to take a series of steps like practicing draws or doing...
Your Honor, I objected. This is no foundation as far as this case goes. Talking about officers, no foundation.
Okay, counsel, I am going to sustain the objection. Do you want to lay additional foundation?
Yes. In your experience and training in your current profession, have you looked into how Taser training is done?
Yes. Axon Enterprises, the manufacturer of Taser, has some pretty clear requirements about the training that they require officers to go through to become certified as Taser users.
And does that training talk about weapons confusion?
Yes, it does.
Does it also talk about carrying the Taser on the non-dominant side?
Yes, it does. Or
So-
at least I should say many iterations of it do. I think they're on version 22 or version 23 of the training, but many, many iterations of it do, yes.
And so this second bucket, I think you were saying, involves educating and training officers, correct?
That's correct.
Is there more that you wanted to add for that bucket, or is that the bucket?
Your Honor, object to that question. Vague in general.
You may answer. Objection overruled.
No, I think the second category can be classified as training officers to be aware of and to mitigate the risks of weapon confusion.
And what is the third bucket then?
The third bucket is really the Taser itself and the differences between the Taser weapon and the firearm that an officer might carry.
And like what kinds of differences?
Depending on which model, there can be a number of them, but the differences that persist between models, or that have persisted between all of the recent models of the Taser, Tasers have a manual thumb safety. That is, in order to activate the Taser device, in order to pull the trigger and have it do anything.
Your Honor, I object to this lack of foundation.
The objection is overruled.
May we be heard in this?
Yes. My original ruling stands. You may
Okay, so-
continue.
Thank you. I think you were just describing the basic differences, or the basic makeup of a taser to try and differentiate it from a firearm, correct?
Yes, that's correct.
And I don't know if you were done, but if you could just finish, please.
Yeah, so the first is the manual thumb safety that the taser weapon has, and a great number of police firearms, including the one in this case, does not have any sort of manual thumb safety. The activation of the thumb safety, that is disengaging the safety so the taser is ready to discharge.
Judge, same objection.
All right, you may have a continuing objection, but Mr. Frank, remember what we talked about.
Yep.
Got to move on quickly.
Want to briefly describe for us the changes that you're talking about? or referring
Yeah,
to?
sure. The second would be the laser point. When a taser safety is disengaged, sends out a little red targeting laser that is roughly aligned with the top prong when the taser discharges. Firearms not equipped with laser sights obviously don't have that visual indicator. Tasers are typically pretty brightly colored now. Bright yellow is the most common for the taser models in a way that the firearm is not. And although I can't really describe this very well, they feel different in the hand. They're at a tactile level. A taser does not feel like a firearm except in the most superficial sense, where anything with a handle and a trigger does.
And are you aware of approximately how many law enforcement officers are out there with tasers working?
I don't have a good...
I object to this also, lack of foundation.
The objection is overruled. You may answer.
I don't have a precise number. The information from Axon and the last agency surveys that I'm aware of suggests that most police agencies have tasers now. I don't have a good percentage of exactly how many officers have tasers, but they are pretty ubiquitous, if not universal, in policing.
And the fact that there have only been, let's say, approximately 20 weapons confusion cases, based on your training and experience, what does that tell you about the three buckets that you talked about earlier?
The vast...
I object to this improper opinion of the witness based on something he doesn't know anything about.
All right. Counsel, do you want to confirm? Okay, I can't, the objection is sustained.
I have no further questions, Your Honor. Thank you.
Okay.
Your Honor, could we have one more sidebar before we start?
Sure. We're going to take a 10-minute break, okay? Thank you. Okay, you may step down. Okay, Mr. Ng, you cited 702. First of all, the question is whether or not the state opened up the door to evidence concerning Daunte Wright's prior fleeing incidents when the expert opined that a reasonable officer in Officer Potter's position could have concluded that Mr. Wright presented an imminent threat of escape but was unlikely to avoid later apprehension in justifying his decision that the taser was inappropriate. So, go ahead. 702 that you're relying on? Or 703?
I'm sorry, I couldn't hear you.
Was 703?
703B, the last
Right.
sentence of 703B is what we're relying on.
Okay, and that does state that the court may admit the data under this rule. Excuse me, I can't read this. Well, if the expert is relying on certain facts in rendering his opinion, I think that we're entitled to get that out. So, Mr. Frank, I'm going to give you an opportunity to tell me why the door hasn't been opened. A limited instruction is always possible.
Yes, thank you, Your Honor. Rule 703 deals with the evidence underlying an expert opinion. And it's basically 703A indicates that all of the facts and data relied on by the expert may be provided to the expert at or before the hearing. If a type reasonably relied upon by experts in the field, the facts or data need not be admissible in evidence. Right? So that's what paragraph A is about. Paragraph B is about the underlying expert data must be independently admissible in order to be received upon direct examination, provided that, so the first part of paragraph B is about direct examination and how it's restricted there. That last sentence then refers to that underlying data. It doesn't say, but on cross-examination they can do whatever they want. It's related to the previous sentence's discussion of the underlying data. So 703B is not a freestanding rule of admissibility on cross-examination. Evidence still has to be admissible and relevant. And you have ruled that any prior conduct of Mr. Wright that is not known to Officer Potter is inadmissible and irrelevant, because the issues in this case are what a reasonable officer knew in Officer Potter's position. That's exactly what this witness testified to. A reasonable officer in Officer Potter's position would have known that he had been identified and could be potentially apprehended later. He didn't guarantee it was going to happen. He said that a reasonable officer would have known that. Now, that might have been wrong. That's not what he's saying. What he's saying is a reasonable officer at that moment would have understood that. It doesn't change anything that there is the unknown incidence unknown to Officer Potter because a reasonable officer in that position wouldn't have had that information. So no door has been opened to put in what is essentially character evidence under 404B. That's what they're trying to do here, is to make it look like Mr. Wright wanted to flee. That's not the issue, right? The issue is what Officer Potter knew to apply that reasonable officer standard.
And there isn't any evidence that, obviously right now, that Officer Potter was aware that he had fled in the past and done whatever acts to evade warrants or whatever. If Officer Potter wasn't aware of that, I believe it's covered under my prior ruling that any prior bad acts, alleged bad acts on the part of Daunte Wright would not be admissible.
May I speak to that?
Yes.
Well, the expert has testified he's reviewed thousands of pages. We don't believe he's reviewed an inch-thick file on Daunte Wright on every time he gets arrested, he tries to escape. Every court appearance he misses. Every time he can get away, he can get away. And so now we have an expert who's articulated that this really shouldn't have been a lethal force matter. No taser should have been shot because eventually we'll find this kid. I mean, that's his opinion. And it's false. We'll find him, he'll be easily arrested, no big deal. And so they've got an articulated opinion they put forth to these jurors. They're writing it down like crazy on their notes. A few of them are anyway. And we need to rebut the falsehood of that opinion. And, I realize your ruling was that since you didn't know about certain things about Daunte Wright, we're limited. But I briefed the 703 issue, and you didn't rule on that yet. Mm-hmm. And I was waiting for this issue to either not be brought up or to be introduced into evidence. And now they've introduced a false predicate into the trial. And a false inference and false facts denies us due process. NAPU versus Illinois. We either have to correct it, or if your ruling is that we can't ask about it, I have to move for mistrial, and we will come in after the break with a thick packet, and I'll make an offer of proof of every time this kid has run away and not been found.
Okay. All right. Mr. Frank, I'll let you just briefly.
Yes, Karen, please, thank you. And I will not pound on the table because I don't think I need to. You can see clearly what the real purpose of trying to offer this evidence is 404B. It's character evidence. But nonetheless, there has been no false impression given to the jury because the witness's entire testimony was couched in terms of what a reasonable officer would have done or known, or what would have been, what they would have done based on what that officer knew at the time. That's been the entire context of his testimony. He never misrepresented that to the jury. He never said, that he was guaranteeing they would have caught him later. That's not his opinion. So his opinion was carefully stated, appropriately stated, and did not open the door to any of this stuff, whether it's an inch thick or not. None of it was known to Officer Potter, and it's not relevant to the issues in the case.
Okay. I'm going to take a break and think about that. So I'll be back in 5 minutes, and I'm just going to read his expert opinions again. And I am concerned about this because I do think that the jury has gotten the impression that he could have easily been apprehended later. And there is a basis for believing that he wouldn't have. So I'll take a break. I'll be back in 5.